Hello, and welcome to this webinar series on the Bribery Act. Today we focus on deferred prosecution agreements. I am Dr. Colin King. I am the Director of the Centre for Financial Law, Regulation and Compliance at the Institute of Advanced Legal Studies. And today's webinar is the fourth in a series of 5 webinars which are kindly sponsored by the Institute of Advanced Legal Studies and by the Society of Legal Scholars. And a key focus of our work in the centre is to bring together different perspectives and backgrounds to examine different aspects of financial law and regulation. And we continue that with today's speakers. Our speakers will talk for between 20 to 25 minutes each. Then we will open it up to Q&A. And please put your questions into the chat box, and we will put those to the speakers at the end. Our first speaker today is Dr. Abiola Makinwa, who is a Principal Lecturer in Commercial Law at The Hague University of Applied Sciences. She is a professional member of the International Compliance Association and served as Chair of the Structured Criminal Settlement Subcommittee of the International Bar Association Anti-Corruption Committee. Abiola is also a member of the Nigerian Bar and is a Senior Fellow of the Comenius Network of the Royal Dutch Academy of Arts and Sciences. In 2018, Abiola co-edited a 66-country IBA study on structured settlements for corruption offences along with Professor Tina Sarede. And he also co-edited a collection published earlier this year by Edward Elgar entitled Negotiated Settlements in Bribery Cases. Abiola, thanks for joining us today. Over to you. Sorry, Abiola, you sound...
Can you hear me now?
Yes.
And can you see my screen?
Yes.
Excellent. Well, good evening, everyone. Thank you so much, Colin, for having me on this webinar. A great pleasure to be here. Also with Constantino and Polly, looking forward to a very interesting discussion, looking back, the UKBA Act 10. And I will kick off this discussion, thank you, by taking a broader look at this. I know that Polly and Constantino are really going to get down into the weeds and the details. And sorry, this is the challenge of having a webinar at home. So what I plan to do is to just kind of take a look back at deferred prosecution agreements. And I'll be taking I'll be looking at 3, if I can get this to move. Yeah, here we are. So I'll be taking you, three key points. The first point will be, how did we get here? And so we're looking at the UK Bribery Act from a situation where there was some serious concern to a situation today where it is one of the major enforcers. I think that is quite an achievement in 10 years. And we will also then look at the DPA structure that has emerged out of this UKBA regime and look at some of the critiques that we have of the DPA's frameworks. And a lot has happened in the last 10 years on the global stage. So what is the position of the UK DPA on the global stage? So that's kind of what I will zip through over the next, I hope, 10, 20 minutes I have, Colin.
Yes.
So it's very interesting to look at the comments of the Working Group on Bribery in the report they had assessing the UK framework. In 1999, they were of the opinion, or rather they had rather serious concerns on the applicability of UK bribery law to foreign officials. And in 2019, they remark that the United Kingdom has become one of the major enforcers of foreign bribery laws. So my question is, what has happened in that period? How have they been able to move from that position of serious concern about the ability to effectively prosecute foreign bribery at all, to becoming one of the major enforcers of foreign bribery rules? And I think clearly, what they had to do was to overcome some of the systemic challenges, which in most jurisdictions impede the best laid anti-foreign bribery rules. So you can have perfect laws, fantastic systems, but these systemic challenges have to be overcome if you're going to have effective enforcement. One of the key challenges is the nature of the transactions themselves. They're extremely complex, they are usually transnational, they're multi-level, multi-layered, very hard to determine the nexus of control. And this is compounded in a digitally, transparently, increasingly transparent, technologically driven, shrinking world. So that is a challenge that the budgets of most enforcement authorities will be very hard put to meet. Again, I think flowing on from these are the profound information asymmetries, where you have these kind of very complex structures put together by the best minds, the best lawyers, the best IT specialists, and really without any inside information to get to grips with the evidence you need to establish a criminal burden of proof beyond reasonable doubt is quite a tall order. In addition to this, we have the lack of political will. The actors that are involved in this, in foreign bribery, are the very highest levels of our societies. These are the blue chip companies that are very well connected. And in any event, politicians will show a natural reluctance to prosecute their domestic corporations that have such an impact on their economies. So there is a problem of a lack of political will. Taking the money out of the crime without killing the golden goose is also a significant challenge. The corporations are not the bad guys. They sustain our way of life. So somehow we have to square that circle and recognize that, the character of the wrongdoer and the need to ensure that we are not doing ourselves even more wrong in how we tackle this challenge. Another systemic challenge that flows out of what I've just mentioned is the collateral damage to innocent bystanders. When you punish a corporation, who are you punishing ultimately? The shareholders, the consumers, the employees. So that's something that we have to take into consideration. A corporation does not have a body to be thrown into jail. And I think for me, one of the key systemic issues is also the fact that a focus on punishment doesn't address the true costs of bribery, in the sense that, and the OECD gives a very good example. When you, in a traditional criminal prosecution process, want to punish the giver of a $1 million bribe, the whole structure is focused on that $1 million bribe. And the punishment, the charges, everything are focused on the $1 million bribe to possibly a foreign official in a recipient demand side country. The problem there is that the damage that is wrought by that $1 million bribe might actually translate to the hundreds of millions, because the cat is already out of the bag. The bribe is already doing its work, undermining governance structures, undermining, increasing costs of doing business, and so on and so forth. So that is another challenge of the focus on punishment. With corruption, prevention truly is better than cure, because you want to stop the cycle, the trap of the damage that is caused by the undermining of the governance structures that we see with grand scale corruption. So back to the UKBA, how did they get from serious concerns to becoming one of the major enforcers, and how have they overcome these systemic issues that I have mentioned? I think this is a great deal to do with the style of enforcement. A style of enforcement that Penny and Constantino will go into depth about, so I'm not going to go into details of what the FCPAs and all of that. You all know, but as I said, more detail will be given in the coming talks. But what I would like to is just to very briefly set the stage for how I feel the UK DPA has overcome some of these systemic challenges and looking forward to what the challenges are that still remain. Here we have a practice that originated essentially in the United States. It's been called by different names: negotiated settlements, non-trial resolutions, structured settlements. I think we've all agreed that we shall call them non-trial resolutions from henceforth. But they are simply any kind of resolution that is arrived at through a process of cooperation between the wrongdoer and the prosecutors, which avoids a full trial, which mitigates the penalty. And these take a variety of forms: DPAs, NPAs, plea bargains, and so on. In the United Kingdom, you of course have a deferred prosecution agreement regime, which is another form of non-trial resolution. The important thing about non-trial resolutions, NTRs, is that it rewards behavior of corporations. And as opposed to just focusing on punishment after the fact, it is looking at the behavior that the corporations have engaged in, the steps they have taken voluntarily before any investigation, discovery, or prosecution by the regulatory agency. So that is a really important characteristic of these type of this enforcement approach. And it is very key in the field of economic crime because of the nature and the character of the wrongdoer. And we find this approach in the broadest convention of them all, the United Nations Convention Against Corruption, where it encourages three key aspects to this public-private cooperation in fighting financial crime. Article 7 of UNCAC speaks about self-reporting, enhancing accounting and auditing standards to stop corporations from cooking their books, and encouraging cooperation by mitigating punishment. Calling on all member states essentially to put into place regimes that encourage public-private cooperation so that we can begin to overcome some of the systemic challenges that have impeded white-collar crime enforcement. So what is the UK's response? The UK model of NTR, the Deferred Prosecution Agreement, was described by David Green as a new and imaginative tool to deal with serious economic crime committed by commercial organizations. One could almost describe DPAs as a form of social engineering, because, as I say, they center on this key question that it plays out in that space of prosecutorial discretion. Do we prosecute or do we not prosecute? How do you tilt the scale towards non-prosecution? And in that space, it is quite interesting how you can shape the behavior of corporations. And I think that is really the very interesting aspect of this. Rather than looking for rules and loopholes in the rules, corporations are now, the focus is on how do we shape the behavior of corporations. Since the DPA, the UK DPA regime came into place in 2014, there have been a slew of rules and guidances, and they're all listed here. But I think they all can be summarized in 4 key points. First of all, companies must report themselves, self-report, and they must adopt a genuinely proactive approach of cooperation. So corporate management has to be genuinely proactive in its self-reporting, remediation, compensation of victims, and so on. So there's a slew of behaviors that are worked into the guidelines, that are worked into the rules, that the corporation is expected to show. And this goes to tilting that scale towards non-prosecution. There's also the lack of history of similar conduct. So recidivism and getting away with it, that is also built back into the system. If there's a history of repeat of such behavior, then that also tilts the scale. There has to be in place a systemic attempt by the corporation to ensure that corruption does not occur. in the shape of a compliance program. This has to be genuinely proactive and effective. And in addition, in the United Kingdom, the role has an oversight role. So here we have, I think I've just summarized all the different rules and guidelines and so on to these key elements, which all, again, I repeat, go to shaping the behavior of corporations. How does this overcome some of the systemic challenges that I mentioned earlier? DPAs affect the corporation in its sphere of influence. All the third parties it engages with, the agents, the suppliers, its supply chain, its employees. So that's a very, I often tell my students that a corporation has a very direct impact on all the persons within its sphere of influence who may never have heard of the FCPA and for whom the rules of the government are so far and distant. But because they are within the corporation's sphere of influence, they fall within that is another pathway to governance, which is immediate and which is direct, and the code of conduct and the agreements that are reached. And it can have a direct impact. It addresses the lack of resources to prosecute all wrongdoers, to establish the criminal burden of proof, as well as the costs of traditional criminal prosecution. I would remember once I was having a discussion with, doing my research in Nigeria with the lawyers, going on and on about private remedies and all of that. And he said, look, he listened very patiently and then said, look, Abby, come. What are you talking about here? He said, and he was really genuinely bemused. He said, okay, think about it. Even if, let's just assume somehow the police, the prosecutors get their act together, can actually get the evidence they need to initiate a case. Assuming they can even do that, it will take what? 3 to 5 years at the court of first instance before they arrive at a judgment. If by any chance the ruling is against us, what happens then? We have deep pockets, we go on appeal, and that will take another 3 or 4 years. And if we lose there, then another 2 or 3 years. So what are we talking about? Between the initial charge and any kind of final resolution, we're talking about maybe 10, 12 years. He said, by that time, the transaction is buried, done. I don't know if the company still exists. So he was kind of very skeptical about, what I was spouting on about. But I think he made a very good point about the costs, the length of the trial in traditional criminal prosecution. So the DPA overcomes that because the company comes to you. The company comes to the prosecutor with all the evidence they need. And, this is where we got them. This is who we gave the bribe to. This is how we gave the bribe. These were the channels that the bribes were given, and so on and so forth. They come with usable evidence that the prosecutors will not have come into on their own. But let me hurry up so I don't think. This, of course, addresses information asymmetry, and it encourages good corporate citizenship. It looks better. Instead of trying to find loopholes, you're trying to behave better. It tackles recidivism. It means reduced costs because there's more efficiencies within the corporation itself. Reduced economic disruption. Collateral damage is also addressed. Increases risk, making compliance the rational choice. And for me, the most important dividend is that the shift from punishment to prevention. You move into the prevention space, and you begin to develop strategies within the prevention of corruption space. And as I said, with corruption, prevention is certainly better than cure, because then you begin to move towards addressing the true costs of bribery and corruption. So that's it in a nutshell, what has happened. Looking back, UKBA 10, the whole DPA regime that has come into place. But there are, of course, criticisms. And what are these criticisms? There are two viewpoints, essentially. One is that it is an erosion of the rule of law, and I'll go into that very briefly. And the other, that it is a catalyst, actually, for the realization of the rule of law, what I refer to as the development viewpoint. So let's look at the rule of law critiques. The central question here is this. I mean, we have criminal laws for a reason. These are serious crimes, okay? That they are categorized as crimes. And if you can negotiate your way out of the full application of the law, how can that be consistent with the rule of law? So that's the fundamental question that DPAs and these kind of agreed resolutions throw up. And there are several variants or several aspects to this that individuals are not prosecuted, or there's not enough prosecution of individuals, so that reduces the deterrent value. It's morally questionable to negotiate settlements. It can lead to arbitrariness, prosecutorial discretion, and it's morally questionable to punish shareholders and investors for acts of guilty individuals. So some have said that, look, this whole DPA regime is window dressing. It is an erosion of the rule of law. And these are legitimate critiques, which, as you move forward in a DPA regime, you have to address these legitimacy questions. And I'll come back to that. The other viewpoint is the fact that the rule of law is only achieved where you have effective enforcement. Otherwise, if your enforcement institutions are compromised, they actually become a layer of protection for those who are doing wrong. So this encourages impunity and not the rule of law. So compromised institutions are not a reliable channel of consistent enforcement. So if there's a lack of political will, if everyone is in bed with each other, if there's an old boys network, or call it what you may, and nothing is happening, you may have the best rules that you can imagine, but the rule of law is not served where there is little enforcement. So, and well, we know, we started this discussion saying that in 1999, there were serious concerns about how the UKBA was enforcing its bribery laws. And so history shows, if we look back, that traditionally, there has been very little prosecution. And therefore, if we do want to achieve the rule of law, we have to develop systems that can bypass compromised institutions to provide alternative pathways to governance. And this is possibly what the DPA regimes have done by bridging these governance vacuums and moving from no enforcement to significant enforcement, from serious concerns to becoming one of the major enforcers. I think that is no mean achievement. And this is, I think, pretty much the result of the approach to enforcement that has been adopted. And I think for this reason, Lord Justice Leveson in the first DPA actually stated that the DPAs were in the interest of justice. Speaking about this case, he said that, and I moved to the third paragraph, that's a lot of text on the screen, my apologies, but I really like this quotation, so I put it there. He felt that by adopting this self-reporting DPA process, the bank had better served its shareholders, its customers, its employees, and this approach had a much better chance of repairing and ultimately enhancing the reputation and its business, and by extension, its role in the economy, by extension, our place in the economy, and so on. So that's the thing about the DPA, the way it feeds into a much broader discourse. And when we look at the level of enforcement, not so much the number, but just the type of cases that have been brought by the SFO, these are top tier companies. And between 2015 and 2020, we see outcomes. And I think that is why DPAs are the UK is described as one of the major enforcers. I'll move to my last point. Colin, how am I doing for time? I hope I'm not rattling on for too long. I can't hear you.
Oh, 1 or 2 minutes left.
Ooh, all right. I'm just gonna zip through this bit, and let's see. Now, a lot has happened in the last 10 years. Many countries have adopted DPA non-trial resolution regimes, including the United Kingdom with its DPA. What does this mean? We now have challenges and gaps. Challenges, we now have many countries running after the same company over the same facts in several jurisdictions. So we now have questions like who takes the lead? What language? I mean, is a DPA in the United Kingdom the same thing as a DPA in France? What about the court? In some countries, there's oversight and others there's none. How does that work? You know, the same. And what about transparency? What about predictability? So these are questions, legitimate questions that need to be answered. They're promising signs. We see increasing global settlements. Airbus is a great example. We see new mechanisms and policies, for example, the anti-piling on policy of the DOJ. We see the International Anti-Corruption Coordination Center, which is a group effort of prosecutors. And also, you know, people like Tina and Peter have put recommendations before the OECD on the need to arrive at some common frameworks. There are some gaps, and I'll just run through them very quickly. Victims. How do they fit into this new framework? This has become the primary mechanism of anti-bribery enforcement. Where do the victims fit in? So here are some suggestions about how they can be structurally included in the DPA process. Another question is, what about the demand side? And again, there are suggestions about how that can be done. And we also need to tailor our education to the prevention space, moving beyond compliance, moving from know your customer to know your data. So I have several thoughts and ideas about this, and I recommend that you can, you know, find one of these books or things that I've worked on, because there you will have a fuller description of what I've tried to zip through in 20 minutes. What do I conclude? The UKBA at 20. I feel that the UKBA and its DPA framework provides the nuts and bolts for robust public-private cooperation in financial economic crime enforcement, with its Section 7, strict liability offense, adequate procedures, role of the courts, victims' compensations, and requirements regarding compliance programs. This is a robust model for countries where anti-bribery is still of serious concern, in most countries, that is, and gaps do remain. Okay. The architecture is incomplete. It is a very young system, and it needs to be tweaked, it needs to be fixed. And I think that's probably what we'll spend the next 10 years doing. Thank you very much, and apologies for running a little bit ahead over my time. Thank you.
Abiola, thanks very much for that. That was a fascinating introduction to non-trial resolutions, and it sets us up really nicely for the next two talks as well. So our next speaker is Polly Springer, who is a partner in the Global Investigations and Contentious Regulatory Group at Eddleshaw Goddard, and Polly specialises in corporate crime. Polly previously served as Head of Strategic Intelligence at the Serious Fraud Office, and she worked for several years as a corporate investigator and an investigative journalist. Polly has been recommended in legal directories in private prosecution, civil fraud, corporate crime, white-collar crime, and she was recognised by Global Investigation Review in its directory of the top 100 women practicing globally in investigations, and she was shortlisted for the Employed Bar Awards in 2018. And Polly, I don't know how you find the time to do all of this, but you're also the author of Deferred Prosecution Agreements, the Law and Practice of Negotiated Corporate Criminal Penalties in 2014, and a co-author of Arledge and Parry on Fraud for the 4th and 5th editions. Polly, thanks very much for joining us today. We pass over to you.
It's my pleasure to be here. Thank you. And sorry I was late to join. I sort of am an amateur academic. I'm actually just a workaday lawyer, but I like to pretend sometimes that I get to hang out with all of you and talk about things from a much more elevated position. So that's probably why there's the publishing in my background. It was really interesting, actually, to listen to what Abby had to say, because that is the discussion that we were having in the UK back in 2008, 2009, when I was at the Serious Fraud Office, and we had this project running that we called the New Tools Project. Back before DPAs were DPAs, it was just a gleam in the eye of Richard Alderman, director of the SFO, who knew that he wanted to bring in US-style negotiated settlements, but there was not a mechanism in UK jurisprudence for him to do that. And he was trying lots of different methods to try and find a way that you could negotiate with corporates for all the reasons that Abby was laying out. That the SFO did not have a good track record of success of holding corporates to account. And the UK corporate criminal liability rules made it very difficult to prosecute a company, and the attribution principle was keeping prosecutors on their toes. And, if we're being fair, there was probably one eye to the slightly death-defying judgments and fines that were being levied by the DOJ that the SFO could only really look to with envy. And all of the reasons for or against that Abby was just running through, that was the same discussion that we were having then. There was an enormous group on one side that were saying, it's not fair. We've got 5,000 years of criminal law that all dictate and mitigate towards a certain disposal of judicial outcomes in criminal cases. And then on the other hand, the pragmatists were saying, but they're not working. That type of criminal law, however historic and time-tested it may be, is not generating the outcome we need to deal with the modern world where you have disintermediated corporates and no clear mens rea that you can attribute to a specific individual or group of individuals. And thus you have much, much wrongdoing in the world, which is simply not being addressed. So I'd like, if I may, to lower the tone enormously and take a really personal look at DPAs, because I was there at the very beginning, and I was there when these discussions were being had in 2010, 11, 12, culminating, of course, in 2013 with the Crime and Courts Act passage. So we're going to start at the beginning. Now, this is just a suggestion to anyone who does want to write a long and boring book about a very niche area of law. Don't do it before there's any law to write about. When I sat down in 2013, when the Crime and Courts Act had just been passed, but DPAs were not yet in law, I decided that my idea would be to pull together the body of jurisprudence that all of us practicing lawyers would need in order to advise clients on how to go about getting a DPA before there had ever been one. And this was a little bit of art, a little bit of science, and a little bit of mysticism, probably all mixed up together, because we had some American law, and DPAs in the UK are largely based on the American example, whatever the judges tell you, and they'll deny this strenuously. There are many similarities between the procedure that we've codified here in the United Kingdom and the procedure that's codified back in my homeland. Just a side note on that, even though I walk and talk like an American, I'm not an American lawyer. I'm only qualified to practice here in the UK, so I can speak with some authority on the differences between our two great nations. So back in 2013, I wrote this book. It was based on the US law, and then it looked to all the precursor cases. We had cases in 2008, 9, and 10 where Richard Alderman of the SFO was trying out, he was pushing the boundaries of what the judges would permit in terms of negotiating settlements. At that time, he was heavily reliant on the Proceeds of Crime Act, Part 5 of it, which allowed for civil recovery.
Well, apologies for the disruption at the moment. Polly has lost connection.
Moving on from Part 5. So there was a huge amount of interest in trying to get deferred prosecution agreements into law, which the UK successfully was able to do in 2013 with the Crime and Courts Act. Now, this is just a little bit of a whistle-stop tour here of what has happened since then, because now, of course, we do have a body of jurisprudence. So the reason I showed you all my book was not to plug it, but to tell all of you not to buy it, because it's well out of date if you were considering it. Unlike the works that Abby put on the screen, I would highly recommend that you disregard it, because there has been so much that's happened since 2013 that you're better off looking at what we've learned since then. Everything before that was slightly speculative, trying to figure out how the courts were going to react, and now we know. From 2013, with the passage of the Act, we then had in 2014 the development of Schedule 17 and the DPA Code of Conduct, which was released in February with DPA, to wait a good year and a half until November of 2015 before the first DPA came to pass. That was Standard Bank. And I was interested to hear Abby's take on that, because those of us in the trenches have a very different view than Lord Justice Livison of the effect of that DPA. Following on from Standard Bank was SARCLAD, which we all knew as XYZ for a number of years because there was ongoing prosecutions of the individuals in that case, unsuccessful. We then had the big one, the first big one really to come through was Rolls-Royce in 2017, followed swiftly by Tesco, sort of like London buses, no DPAs for 2 years, then two come along at once, years and years and years. There was 50 odd lawyers at Deckert who were working on that case. It started to feel like it was waiting for Godot, waiting for the Airbus DPA, but eventually it did come around. Followed up by G4S. I do want to come back to G4S as well, because you need to compare that to the Serco case. Serco and G4S are the exact same case. It was the exact same misconduct with the exact same victim. And just in the last month or so, we've had Airline Services Limited, which is a little bit of a damp squib after the big show of Airbus earlier this year. Airline Services is much more in the vein of Gerald and Standard Bank, which was smaller historically. So moving on from the damp squib of Airline Services, I wanted to just make one brief point about the nature of the DPA process. DPAs, we think about them as being one final outcome, but for the practitioners who are actually trying to obtain one and the clients who are seeking that outcome, this is not a single moment in time where a DPA is asked for and then received if you're lucky. It is a whole process that needs to be gone through before there is any hope of a DPA coming to pass. Quite helpfully now I can't advance my slides, Colin. Sorry.
Holly, no problem at all. So if you want to just talk over your slides as if there is no slide. So we still have the DPA process slide in front of us. Now it's moving on to the Standard Bank one.
So you can see the Standard Bank slide?
Yes.
Right. So let's have a little whistle-stop tour of what DPAs we've had in the UK so far. Standard Bank was the first one. And it's a really interesting case because it was something that if I believe if this case came before any practitioner today, the advice would be you do not need to self-report. But Standard Bank had different advice, and they were advised by a former head of division for the SFO, and DPAs were new and they were available, and the general sense was if you discovered misconduct, you should immediately go and self-report it. Things have changed slightly now. It's not quite so, there's not quite such a swift willingness to go to the SFO with anything you find out. The speed of the self-report was incredible. It was within days of finding out about this that a formal self-report was made to the SFO. What ultimately mattered about this? There was a great deal of applause for the fact that Standard Bank came quickly. The decision was, there was a lot of nervousness I mentioned before, which may not have made its way to you given the technical problems. But what I was mentioning was that Standard Bank was not a case where there had been lots of toing and froing between the prosecutor and the defendant corporation before the decision came to the SFO as to whether or not a DPA should be offered. Ultimately, the case turned up and there was a very swift decision made. It's true also that the SFO had a certain amount of nervousness about this first DPA because of all of that, on the one hand, on the other hand, discussion that Abby was discussing before. They wanted to make sure that the very first case that came through, there could be no suggestion that the defendant corporation had had an easy ride of it. So when Standard Bank arrived, they had a full internal investigation, they gave full cooperation, they opened the doors and showed the SFO everything. This was an easy decision for the SFO to make. There were a number of other cases, in fact, some of the ones that ultimately became a DPA, which actually started long before Standard Bank. And I've got a sort of slide setting that out later on. However, when Standard Bank arrived, it was so clean and so tidy and so easy, it made sense to put this one forward first. SARCLAD, not so much. SARCLAD was very messy. Although it was the next DPA to come forward, it was very historic conduct. It was sort of nearly a decade old, some of the misconduct that was being self-reported there. It was also lots of individual incidences. Standard Bank was just one transaction. It made it very simple to quantify, simple to put the evidence together, and therefore simple to take decisions. Also in Standard Bank, anyone you could have prosecuted, any individuals, they were overseas, they were out of the jurisdiction. The SFO didn't need to consider whether or not there were going to be individual prosecutions alongside that. But SARCLAD was different. There were prosecutions of 3 executives, and that led to the first an anonymity order, which meant that the company wasn't actually named because it would have prejudiced the trial of the individuals. What do we need to take away from SARCLAD? It did emphasize that self-reporting is important. Cooperation and what we now call self-cleansing, although that wasn't a term that was used at the time. Self-cleansing being, we've investigated this ourselves, we've taken remedial compliance measures, we've gotten rid of the individuals and disciplined them and moved them on to their next career step. There was also a feeling that the internal investigation that had been done by McGuire Woods, the law firm that managed this, had been really extensive, as well it should have been. The partner at McGuire Woods who was managing this case was the former general counsel of the SFO. And just as in Standard Bank, there was a strong sense that these were former SFO members who were doing the same job that they had done when they were in the prosecutor's office. Next up came Rolls-Royce. Rolls-Royce was an interesting one at the time and remains an interesting one. It dealt with extremely historic misconduct, but it was enormous. This dated back over many years, many jurisdictions, and also it had not been self-reported. Private Eye and The Guardian were writing about Rolls-Royce long before Rolls-Royce ever set foot through the door of the Serious Fraud Office to discuss the misconduct it had identified. The takeaway from Rolls-Royce for all of us, it depends on how tongue-in-cheek you care to be. One takeaway might be, if you're big enough and relevant enough, then your failure to self-report won't be fatal. If you're a defense contractor whose commercial impact on the jurisdiction is so significant that the prosecutor needs to bend over backwards to make sure that you are not debarred from future defense procurement contracts, then a DPA will be in your future. But whatever the side-eyeing that went on, Rolls-Royce was successful in negotiating a DPA, and the SFO was very happy to have it. Prosecuting Rolls-Royce would have been the most monumental task. Abby mentioned before this idea that the investigation, the prosecution, the trial, the inevitable appeal is so lengthy that in some of these instances with giant multinational corporations, there's just no possibility that you're going to ever practically result in a conviction. And so it begs the question of whether another disposal of that misconduct should be attempted. What really matters about it, I think at this point all we can say is if there are certain other exceptional circumstances in play, the lack of a self-report will not be fatal to obtaining a DPA. Then we had TESCO. TESCO stands alone in this body of deferred prosecution agreement jurisprudence. It is the only one that does not relate to corruption, although, of course, the charges that were brought in Serco and G4S were for fraud, but arguably these were sort of tantamount to corruption, given that it dealt with a fraud against a government department. But at the time, TESCO was a pure accounting failure, and it very much then and now sits outside the general tone and tenor of the other DPAs that have been agreed in this jurisdiction. There was again applause from the judiciary for TESCO having done a thorough investigation, for having made a detailed self-report and given whatever cooperation the prosecutor asked for. Then Serco Graphics followed not long after TESCO, and it was a really interesting case at the time. It dealt with a contract between the Ministry of Justice and and Serco for the provision of ankle tags, and this contract had been in place for a number of years, and for many if not all of those years, Serco had been overcharging the Ministry of Justice, and the detail of how they did the overcharging probably we don't have time for, but it had to do with the amount of profit that Serco was allowed to derive under this contract, and how it stated its profit back to the Ministry of Justice. So there were 3 offenses of fraud and 2 of false accounting that came out of this scheme. But when the scheme came to light, when this overcharging was discovered, Serco was quite quick to first disclose to the Ministry of Justice and then ultimately engage in cooperation with the Serious Fraud Office. And this was in contrast to a DPA that came later with G4S. Ultimately, there was also some consideration given to the fact that Serco PLC, the parent company of Serco Geographics, was quick to take on some of the punishment for its subsidiary, and that was determinative in the finding by the court that a DPA was in the interest of justice. Next up came Geralp Systems, and Geralp Systems was more similar to the Sarklad case. It was an industrial manufacturer. It dealt with payments overseas. It was quite historic. There were prosecutions contemplated and ultimately attempted against the individuals in Geralp, but ultimately the company itself found that it did not pay as significant a penalty as had been levied in the early cases of Standard Bank and Sarklad, mainly because it would have killed the company. And this was a careful decision made by the court that if we are deciding that this company does not need to be the subject of a criminal prosecution, but instead an alternative disposal can be sought, then we are accepting that there is justification for the company continuing in some form or other. If our fine and our penalty is going to kill the company off completely, then perhaps we should consider whether a different disposal and some greater leniency in terms of the level of the fine should be granted. Finally, Airbus, as I said, this was the biggest to date, 991 million euro fine. This was part of a huge global settlement involving law enforcement authorities in France and the United States, a total of 3.6 billion euro paid overall. The misconduct covered 5 different jurisdictions: Sri Lanka, Malaysia, Indonesia, Taiwan, and Ghana. But over a relatively brief period, just between 2011 and 2015. Looking back at similar cases, Rolls-Royce and the earlier case I mentioned, BAE, Airbus really fits into that group of cases, big defense contractors, number of jurisdictions involved, and trying to come up with some kind of penalty that would both address the seriousness of the misconduct, but also allow the company to continue, not to punish the shareholders, customers, suppliers, employees, and so on, whose fates and fortunes were so closely intertwined with that company. Airbus did self-report, and it did do an absolutely enormous internal investigation. Deckard was the law firm that led it. Deckard had 40, 50, 60 lawyers at any one time who were working on the review of documents and the internal investigation. There was extensive coordination and cooperation with the prosecutors, consultation done as to how sensitive defense documents might be disclosed so that the SFO could get comfortable with agreeing to a deferred prosecution agreement as opposed to a prosecution. I think it's fair to say that in the case of BAE, Rolls-Royce, and Airbus, a prosecution would have been theoretically possible, but practically highly implausible. Next up, there was G4S, a more recent one. G4S was another company like Serco, admitted to the same misconduct for having misled the Ministry of Justice in its provision of electronic tagging, electronic monitoring services. G4S, for reasons that I'll come on to if I have time, paid a higher penalty than Serco. And in shorthand, this was because whereas Serco fell on its sword, G4S unsheathed its sword and went to war. So there was a very different approach between the two companies for the exact same conduct. What do we take away from G4S? Well, this is where we have to start threading an increasingly fine needle when it comes to self-reporting. G4S decided to cooperate with the SFO very, very late in the day. And the judge, in coming to the conclusion that the DPA was in the interest of justice, decided that late cooperation was not fatal, but that we would address the fact of late cooperation with a gradient as opposed to in a binary way. In other words, we'll look at the level of the cooperation, and then we can just decrease the discount on the fine if we feel that cooperation has been less than fulsome. And then finally, Airline Services Limited. This is the most recent. The fact that it's the most recent is the only reason it really gets a slide of its own, because this was quite a small matter. We're dealing with one agent of this company, Airline Services, which does the sort of manufacture and adaptation of aircraft interiors. They needed to get contracts with airlines, and we're using one agent for the obtaining of a contract, who was also first a contractor and then an employee of Lufthansa. And this case did take a while to get through. The DPA was negotiated by my former firm, Eversheds, when I was still there. I left Eversheds in 2017, and the case was running for the whole time that I was working there, and the DPA was only agreed a few weeks ago. So despite the fact that it was a relatively low level of misconduct, and despite the fact that the self-report happened as long ago as 2015, the white-collar bar in London is somewhat baffled as to why it took 5 years to get what was a fairly anodyne DPA when you put it alongside Airline Services, alongside Airbus and Rolls-Royce and Tesco, which were much more enormous undertakings. It's also fair to say that Airline Services is now a dormant company. There was nothing left to prosecute. So it may well be that by the time the SFO came to consider whether or not to prosecute on the basis of the self-report, there was no one there to go after. I appreciate my technical difficulties have caused us to go, or me to go slightly over time. So I'm going to stop here, but I want to end with just a brief point to say that alongside these DPAs, if you want to get stuck into our new body of jurisprudence on deferred prosecution agreements in the UK, you should look not only at the settled judgments and the DPAs that did come to pass, but also at the ones that were related to and around the corners of the deferred prosecution agreements that were successful, and look at ones that were not. So for example, the SFO attempted to prosecute Barclays. They not only didn't succeed in persuading Barclays to enter into a DPA, the SFO also was not able to prosecute any of the individuals around certain misconduct that Barclays was alleged to have engaged in around the time of the 2008 financial crisis. Equally, Sarclad and Tesco, attempts were made to prosecute individuals in those cases. No acquittals across the board. There's not been a single individual prosecuted by the SFO as a result of a deferred prosecution agreement. So that objective that Abby mentioned in the beginning, that it would, DPAs allow one to hold a corporate to account, hold individuals to account while also allowing a corporate to continue as a commercial entity, hasn't really played out in the UK experience. We also have some helpful jurisprudence from the case of ENRC, which is this bizarre ongoing investigation, which has led to a whole slew of civil litigation between ENRC and the SFO, ENRC and its former lawyers, ENRC and some investigators who are working for those lawyers. But we still do not have either a prosecution or a deferred prosecution agreement, despite that the case, and this is going even further back, I left the SFO in 2010, the case was ongoing then. So we're a decade in for no product. What we do have is a lot of really helpful case law because ENRC has been fighting this very, very hard. There are a couple of sad cases down the bottom there. I won't talk about Smith & Usman. That was a successful prosecution of a company under the old bribery law. But Skansen Interiors is the only company thus far since the passage of the Bribery Act in 2010, which has attempted to raise in trial the Section 7.2 defense of having in place adequate procedures. They raised it unsuccessfully. The interesting part about both Skansen and Sweet Group is both of these companies self-reported. Both of these companies have, and their cases and the misconduct that the cases addressed were very, very similar to the likes of Sarclad or Airline Services Group or even Standard Bank. And yet, and both Skansen and Sweet Group thought they were negotiating a DPA, and what they ended up with instead was a criminal conviction. Sweet Group on a plea and Skansen Interiors after a trial. So I would urge anyone who's interested in this to take a look at those cases as well. I'm going to pause there and hand over, and again, fulsome apologies for my technical difficulties.
Polly, thanks very much for that. And our final speaker this evening is Dr. Costantino Grasso, who is Senior Lecturer in Law at Coventry University. He is an expert in corporate social responsibility, business ethics, and financial crime, and is also the editor-in-chief of the Corporate Social Responsibility and Business Ethics blog. Costantino has served as a consultant, an advisor, and lecturer on these different topics for the European Union and the Council of Europe, as well as national governments and firms in Europe and North America. Being qualified as a solicitor in England and Wales and as a lawyer in Italy, Costantino has always combined academic activities with his legal practice. And in 2014, Costantino worked as a corporate governance and compliance specialist for the SFO, participating in the first UK DPA, which is between the SFO and Standard Bank, as Polly just mentioned. Costantino, we pass over to you.
Colin, thank you very much. First of all, let me say thank you very much for inviting me. It's an honor for me to stay here with you and with Abiola and Polly. And thank you for the kind words, introductory words. Yes, I had the privilege to participate in the investigation, actually for both Rolls-Royce and Standard Bank. In the Standard Bank DPA, I also participated directly in the negotiation, and I was tasked with the task of conceiving the corporate governance solution to be applied to the bank. I could speak about these experiences so much, but it will require another seminar. So what I would like to do right now, let me share the screen. So what I would like to do right now is basically, I won't praise the DPA. Abiola has already said so many good things about that. I will look at the advantages of the DPA, but this time to be skeptical, because I think that some issues that we have about DPAs are relating to the advantages that they give to the system. So there is, I think, an intimate connection between the success story of DPAs because of their advantages and the issue that we face in relation to other matter like the rule of law and most importantly, the lack of prosecution of individuals. These are strictly, to my mind, interconnected. So I will be a bit more skeptical. I wrote an article on DPAs in 2016 where I praised the act. Now I will try to share with you my skepticism. So let's see if I'm convincing or not about this. So first of all, when you go on the SFO website, you see the characteristics of the DPAs, and these are the 4 points. So it says that they enable corporate body to make full reparation for criminal behavior. Let's take this for granted. It also says that they avoid lengthy and costly trials. Okay, this is for sure, but also doesn't mention, and this is a bit weird because they are prosecutors, that they also avoid lengthy and costly investigations more than trials. And then we have other 2 points that I have some doubts about. They say that they are under the supervision of a judge. It's true, this is true. And of course, if we look at the terms that are fair, reasonable, and proportionate, no issue about that. But then when we look at the issue of the interest of justice, everything become a bit obscure, and we have to delve into this topic, I think, a bit more. Then they say that it's a transparent and public event, and honestly, I have my doubts about that. I mean, there is a level of transparency, for sure. It is fully transparent. Of course, it is not. And the problem is that it should be, because this is an instrument that is in the public interest. So the public interest is one of the most important things to be evaluated. So the transparency level should be the maximum one. So let's try to look at the advantages again. We saw then for corporations, of course, they are very advantageous. They safeguard their reputation. They corporations avoid disruptive consequence of proceedings. They avoid the mandatory debarment, blacklisting for barbie procurement, and they can calculate the costs of the negotiated resolution so that it does not disrupt the business activities. So this is very important. But when you look at the list of the advantages for the state, you realize that there are even more than this. So there are more advantages. As Abiola said, these investigations are extremely complex. So if you enter into a DPA, you assure certainty of success. And you get also a lot of money, actually. So this is very good in terms of results of the prosecuting activities for the prosecutors. They do not require long investigation. And this is so important, as Abiola said, especially when you think about the fact that you receive all this material from the company. And when I participated in ICBC case, we just where they're corroborating their evidence. We didn't get any new evidence, but most importantly is that you don't have to rely on the cooperation of foreign authorities in case of transnational bribery, where this cooperation is all but granted. And of course, it is like that, especially if the government in these countries is enmeshed in the corrupt scheme that you are investigating. So that's the big issue. So for example, in Standard Bank, we had not to investigate anything that happened in Tanzania. And honestly, we had no possibility to do that. So it was no possibility to go on with the investigation. It was absolutely impossible. So without the internal investigation documents that has been given to us, I think it was an unsurmountable task to reach, a conviction. So again, most importantly, they avoid altering competition. And what is more important, they avoid putting the investigating firm at a competitive disadvantage or destroying the investigating firm. This is very important. And as Abiola said, these advantages, they are, I think, the best antidote to the lack of political will to fight against influential domestic corporations. So the DPA is giving us this. So we can now go after them because we have this antidote. But the problem is that this antidote is also the poison, because this antidote is inherently inside a political dimension that has to be considered, that a political dimensions of corporate crime. So, so basically, that's interesting because Abiola was looking at the difference between 1999 and 2019. I agree with her, but look at that and something else. There is a time gap that I don't think is a coincidence. This could be a political choice, but of course we don't. This is just speculation. So in July 2011, we had the came into force of the failure of commercial organization to prevent bribery offense. That is so much, as Abiola said, the work of prosecutors, but we didn't have any prosecution for 3 years. And then after the adoption of the DPA, we had all the nice series of prosecutions going on as Abiola and Polly showed us. So why there is this gap? Is this a mere coincidence or they were waiting for something? And we have not to be surprised. We don't have to be surprised. If you look, for example, what in the United States they did in 1998 when they changed the scope of jurisdiction for the FCPA, they at the Senate said basically that they were doing this because otherwise American corporations were operating at a disadvantage, and some trading partners, alias UK, aka UK, have explicitly encouraged to do this business, even let this corruption be claimed as tax-deductible business expenses. So this is an issue. So we know this. Okay, so now we are discussing something that we know very well. Now, why this is relevant? This is relevant with the DPA because as Colin and Nicholas Lord in the book, they said very well, the problem here is basically that this corporation negotiating their way out of the criminal process. And as Brandon Garter said in 2016, when you have this agreement, there is always a series of complex backroom deals. And so that's the point that I'm making to say to you that here transparency has to be full. So the problem is that these corporations are so large and systemically important that basically they are too big to jail, as we commonly said. The prosecutors often lack the ability to charge culpable individuals or enforce structural reforms. So I have even some doubts about what Abiola said, that the innovative scope of DPAs through which you can impose structural reforms, they really work. We have to see that, and unfortunately, the FinCEN scandal has demonstrated, for example, that what they've done with the HSBC was totally not working. So let's just look at 3 specific issues. I have identified more than 3, but you have to wait my next paper about that because I would like to discuss that in a paper. So I will try just to look at 3 issues. The first one is lack of proper transparency, vagueness of the interest of justice principle, and structural lack of focus on individual liability. For the first one, the problem are 2. The first one is that the statement of facts, that is basically the public description of the allegedly perpetrated offense, this is subject to negotiation. So we don't have to forget it. So, and also there should not be admission of guilt because this is merely a potential under Section 5. So basically, there can be a discrepancy for the reality of the facts and what is written in the statement of facts, because it is negotiated. It's not a judicially ascertainment of the fact. The second problem is that how we can then look if there was a backroom deal, or basically the prosecutors wanted the deal because they had no capability of going on, or for any other reasons, where we cannot let the crucial watchdogs and even the judicial authorities actually access the full investigative documents on which the decision to enter into a DPA is based, because prosecutors can decide can select the document that they send out and submit to the court for the approval. So right now, this has to be solved. In relation to the interest of justice, now the problem is here, if you look at this in the classic way, is that this principle has not been defined by the legislature, and so but it's fundamental, because the discretion of the prosecutor should be based on it. And because there is this vagueness, this can be a source of inequality before the law, threatening in this way the very essence of the rule of law. Now, when we started, for example, when I was working on the first case in 2014, we had the code of practice, and the code of practice said the public interest, look, is different. This is not the interest of justice. Even the words I think are important, but the public interest factor are various, and one of the most important one is the seriousness of the offense. And also it said, and it also says, because it's still public, that a prosecution will usually take place unless there are public interest factors against it. So it's like that in 2014, the favor was for prosecution rather than for settlement agreements. And this is, this corroborates what Polly said when he said that the Standard Bank had to be scrutinized a lot because it was the first DPA. But now we are, empirical evidence demonstrated that this is not the rule, that basically the system totally favor settlement agreements. And this is not surprising because we said the advantages that they give. And so then we arrive at the Rolls-Royce case 2017, where the judge affirmed that irrespective of the seriousness of the offense, and as Polly said, also the fact they failed to self-report, there were so many things to take into consideration to give Rolls-Royce the agreement, and among them, the adverse effect to the UK defense industry, consequential financial effects on the supply chain, impairment of competition in a highly concentrated markets, potentially significant fall in share price, and also group-wide redundancies. So these are the criteria, and I think just a couple of months ago in October, the SFO has published a chapter from the handbook and is basically affirming the same things and saying that basically there are some elements that play against prosecution, and these are when there are disproportionate consequences for the company, where there are potential debarment blacklisting, or where the conviction is likely to have collateral effects on the public. Now, what is the problem with this? The problem with all this is that this, from a theoretical point of view, is problematic, because this is creating basically two categories of corporations, the one that are strategic and the one that are minor. So we don't know what are, in terms of predictability, when you will be considered so strategic to be to jail, basically, or where not. And so I see four issues. First of all, that this criteria should be clarified by the legislature or the judiciary, because there is an inherent conflict of interest for the prosecutors to set their own limits. Then that there is an absence of order of priority among these various factors. So for sure now we know, as Polly said, that failed reporting or late cooperation are not so important, but these strategic points are more important. And also that the decision appear based on political consideration, because of the political dimension we're speaking about. And this is an issue. And this is an issue also in relation to Article 5 of the OECD Anti-Bribery Convention, because it says basically that prosecutorial discretion should not be subjected to improper influence by concerns of political nature, but should be a techno-legal decision. Fourthly, how are these collateral effects that are so important assessed? So they are assessed through common sense. They are not assessed with formal technical advice. They can be also, troublesome for the prosecutor. But this is another big issue that we have to look at. And now, the last thing I would like to look at is the absence of course, enforcement in relation to individuals. This is happening in the United States so far, but also we saw that also in the United Kingdom, Sarklad and also Guralp and also Tesco, all these big defeats for the SFO, they dropped the investigation on the individuals. And to speak about the first, just Polly mentioned Standard Bank. We really wanted to prosecute an individual. I can say this in general terms, but we didn't have the evidence to do that. And we didn't have the evidence because of the DPA structure. So the problem here is that basically what we have to understand is if the advantage of the DPA is to avoid a full investigation, so this is fantastic for the investigator. It means that, is it true that all the evidence you need is given to you by the company, but all the evidence you need to enter into the DPA, not the evidence you need to prosecute the executives. Now, if you want that evidence, you have to go on with different investigations, full investigation, intrusive investigative techniques, especially when you speak about shady deals and corruption. You cannot do this on the basis of the corporation DDO. And I find a bit of naivety in the DOJ Yates Memorandum 2015 that tried to solve this problem when they said that basically the corporation must identify all the individuals involved, responsible, and give the evidence to the DOJ, or they won't get benefits. But how you can understand if they're doing that or not if you do not do the full investigation? You will never know it. You cannot know if the corporation is hiding something to you. And because of the incredible advantage of the DPA, that basically means that you don't have to do the full investigation, we are stuck now in a big issue. So I leave you with this big question mark. And I would like to say thank you very much for this.
Costantino, thanks very much for that, and thanks to all three of our speakers this evening for what I think is certainly a fascinating insight into how DPAs operate in practice and how they have evolved. So as I mentioned at the outset, if you have any questions, please do use the Q&A function and we will put them to the speakers. But can I get the ball rolling on this, and can I put a question to both Abiola and Polly? And Abiola, you mentioned in your talk the classical approach to criticism of DPAs, and I think we might see that there with Costantino's skepticism towards how the regime has evolved in the UK, and Costantino mentioned his skepticism in relation to structural change, for example, whereas you spoke about DPAs potentially shaping the behaviour of corporations and potentially preventing bribery. So could I ask you, do you have any thoughts on Costa's view? And then my next question would be to Polly. Again, just picking up on an issue that Costantino mentioned, because Polly, you spoke about the lack of prosecutions of individuals and that no one has been prosecuted by the SFO arising from a DPA. And Costa's argument here was that the DPA structure undermines the potential for individual prosecutions. So do you have any thoughts on that? So if I come to Abiola first and then come to Polly.
Thanks. Well, I really liked your analysis, Costantino. The antidote is also the poison. That was very, very well put. And I don't want to be seen as, being the cheerleader for DPAs. Not at all, not at all. I'm simply describing a process, starting with the systemic issues and moving to where we are, but there is still, the architecture is not complete. So the politicization of DPAs or the politicization of white-collar crime enforcement is a fact of life. Look, I come from Nigeria originally. I'm also Dutch, but the regulatory pyramid is so easily held hostage by the political elite. And that is the fundamental problem. So when we criticize this approach and legitimate, I think they're legitimate criticisms, the question is this: what alternative are we proposing that bypasses these, noted criticisms? So I think it's good to criticize, because then I think there we see the weaknesses of the system that can be fixed. But so sometimes I kind of wish that how can we push this discussion a little further? Because I do wonder, and listening to you and listening to Polly, are you seeing in your practice, in your research, a drift away from Section 5, a drift towards the politicization of DPAs, which is now creating that space where corporations will take the cynical choice of not reporting, because we're moving into a system where we're moving back into that situation where we had with traditional criminal prosecution, where you basically you could game the system. So are you seeing a drift towards the politicization of this system? And would you then be advising corporations not to self-report because of whatever trend it is you are beginning to see? Is that the direction in which we're going? And the last thing is, I understand we have a tradition of punishment and deterrence that is based on, should I say, the shock factor. And that doesn't translate into, this corporate punishment. But if we take a step aside and look at the nature of white-collar crime, it is systemic. I think it's very nice and good to say we want to hold individuals accountable, but I think that also flies in the face of the fact that corruption on this scale is not one bad apple. It is systemic it is systemic. So while it may make us feel good that we've got one individual here and there, and it's in practice not that easy to establish that nexus, but so what I'm trying to say here is, I hope it's not a little bit of a red herring that makes us feel good and takes our attention away from developing mechanisms. I mean, if you can have a Section 7, maybe you can also have a way of taking the buck must stop somewhere. So where the buck stops, I mean, I'll be very happy putting where the buck stops in jail, as opposed to odd individuals here and there. So, I mean, you could develop alternative approaches to this. So I wonder sometimes whether this, I understand the discussion about individual accountability. However, within the context of the systemic nature of grand scale corruption within an organization, that maybe we need to look a little bit further afield in determining who it is precisely that we throw into jail. We can have a Section 7 throw into jail card, sort of strict liability. The buck stops with you, you go to jail, sort of thing. Now that's just a joke, but that's kind of just to throw that out there.
May I try to answer quickly? Otherwise, I will forget the points, the challenge that you launched me through Obiola. So Obiola, I agree with you. When you ended your presentation, we are on the same line. You said that this is the first step. This is the first step we have to build on it. So I'm not here saying that the failure to prevent offense has not carried good things, and that the DPA has not a potential. Okay, I wrote about that, and I am convinced about this. But at the same time, we have to evolve. We cannot stop now, because there are some issues that we have to address. Now, when I was discussing with Jennifer Arlen about this, the problem is exactly this. If you are too strict and you change this, the companies will not self-report anymore. And this is an issue. And I think that we both agreed, and we all agree on that, we cannot in a way substitute individual accountability or white-collar criminals with the surrogate of corporate liability. So we have to go back to individual liability, and it's not easy. It's not easy, and the problem is that it won't come through the DPAs for the structural things that I told you. And then I also appreciate a lot of the vision of a catalyst approach to the rule of law, but I think rule of law is based on ideals. So this is a utilitarian approach. I'm more Kantian in relation to ideals, at least. So I won't accept this argumentation so easily, but you can convince me.
Costa, I think that is the perfect time now to bring in the cheerleader of DPA. So Abiola, you said you're not the cheerleader. I think we do have the cheerleader of DPA, certainly here in the UK. Polly, over to you.
Would you like me to do a cheer, because I do come from that background, but no, I mean, I have to say it's quite refreshing to have a conversation in these terms, because it does take me back a little bit. This is what we were talking about back in 2014. It's all become much more pragmatic here at the coalface, if I can say that. It is very much a question of, okay, this is the conduct, which case does it fit into? Are we in self-report territory, or are we in go away quietly territory? Are we in lift up the rug, big broom, sweep it under, and everything goes away? And the big picture is not discussed very much. That big picture of is corruption a global and systemic issue that we have magically here in the UK created a solution to? And here's the reason why we take a pragmatic approach. I'm a criminal lawyer, right? I met real criminals. I've met criminals who know more about criminal law than I do, who help me out and say, oh, you know what, actually last time I was banged up, this was what we did for mitigation in front of the judge. Why don't you try that? When you talk about corruption, you're not dealing with those kind of people. And to put it in terms that we can all associate with, Colin, you asked Abby and Costa to join in on this presentation, yeah? You just invited them. What if someone turned up and said to you, well, wait a minute, why did you pick them? Why did you pick Abby and Costa? Is it because you know each other from some former association? Is there something corrupt about this? Is there some reason you didn't put this out to a formal tender? We think there's a suspicious thing here. And we think that if there's even the slightest bit of suspicion around this, we need to investigate it. But we don't really feel like investigating it, because that's quite a lot of work. So the way that you ordinarily conduct your business as academics in the legal sphere, we suggest that if you think you might have stepped over the line at all, you come and tell us, and we'll prosecute you for it. But if you tell us straight away, then we won't prosecute you. We'll just levy the same financial penalty on you that you would have paid if we had prosecuted you and you had got convicted, and then you got a penalty from the court. These are the defendants we're dealing with. These are not people who we go to them and we say, we think you should self-report to law enforcement, and the individuals go, it's a fair cop gov, which I know sounds really great in my accent. That's not the situation. These are people who think they're doing their job. They think they are doing their business as usual. If the system is corrupt and the system is flawed, then the system must adjust. So DPAs are a pragmatic solution to that disconnect between where the ancient criminal law meets the modern corporate. Companies haven't changed since the imposition of the Bribery Act. Our laws have changed. So you take something which has been a totally ordinary course of business for millennia and suddenly say, oh, that thing you do, that's illegal. You can't do that anymore. And then express bafflement when everyone doesn't immediately go, oh yes, I accept that now. I accept that I'm no longer a businessman. I think now I'm a criminal. So this is something that makes it very difficult to kind of bridge this gap between transparency campaigners and transparency advocates and business people who are trying to do what is, let's be fair, if they're operating in these jurisdictions, they already have a really hard job. These are not places where it's easy to do business. These are not places where it's the City of London. You know, these are places where when we're acting for a client, we might one day get called in to discuss a potential DPA, and on another day, a murder on site. That's the level of difficulty of operating in these environments. So, and it is equally not the case, appreciate I'm soapboxing a little bit here, but it's equally not the case that we in the English-speaking world and the developed world are supposed to rock up to these jurisdictions and go, actually, we think that you should apply our norms. We think that the way we do business is better, and therefore you have to meet the expectation and the standard that we have and that we apply. So all of that is, I think, quite a long way of saying that, yes, we have to hold individuals to account, but we have to, even more importantly, be watchful of a scapegoat. The company will live on. Those individuals should not be serving the price for a systemic misconduct. There you go. Is that cheerleader enough?
Thanks, Polly. And I see Abiola wants to come in on this as well. Abiola, can I add in another question before you come in response to Polly's point there? And just picking up on an issue that Polly alluded to about other jurisdictions. And it is one of the criticisms that has been made. So, for example, in the Rolls-Royce case, what about the other countries? So the victim countries, as such, there has been criticism in that regard that they are often sidelined. So do you have any additional thoughts in that regard, and anything in response to Polly's earlier point?
I think Polly and I are actually on the same page on, on this. Let me start with an anecdote. When I was conducting my PhD research, I gave interviews from all over Lagos, and I remember listening back to the interviews. It was very interesting. There was a lot of doom and gloom. Speak to Nigerians about corruption, and they'll go on and on and on. But listening back to those tapes, I heard things like, if I want to do business with the Americans, I have to pass their due diligence. Or, and I was struck by that kind of reference. This CEO knew nothing about the FCPA, nothing at all. Out of self-interest, he wanted to do business, and he was speaking about due diligence and passing their due diligence so that he can do business. So you see, what the DPA regimes have done by shifting the locus to the companies and making them responsible to some degree for corruption prevention, they have a whole new terminology and a whole new way of doing business. We now speak about CDD, KYD, KYC, all of that. All of that has been the heightened risk is what is pushing change. And that heightened risk did not exist under traditional criminal prosecution. So there was no incentive for compliance. It was just, why would you? Okay. If we are drifting with DPAs into a similar politicization of DPA regimes, then it's the same problem. So the only thing that has shifted the needle is the perception of heightened risk, which the corporations have responded to. So from that perspective, to your question, Colin, I think we shouldn't underestimate the sphere of influence of a corporation and how we can use the corporation acting in that space to influence the behavior of along its supply chain. So this is a different way of governing, and developing different systems of governance. And in that sense, all along its supply chain, you can introduce a new way of doing things, new values, new norms, etc. So I think we shouldn't underestimate that. And that's it's like a ripple in a pond, kind of bottom-up change. But it's a very good point. What happens to the demand side of this whole DPA discussion? the FCPA and progeny are a supply side crime, okay, foreign bribery. So the focus is very much on the giver of the bribe, and this has unfortunately or just coincided with Western countries, okay, and the bribe taking countries have coincided a great deal with the rest of the world. So it's not as simple as that, but yes, from a demand side perspective, this actually helps with the problem of lack of political will, and it also breaks down this veneer of absolute impunity, simply because local prosecutors no longer have a monopoly on initiating justice with regards to local acts of corruption occurring in their jurisdictions. So actually, breaking that monopoly is in the interest of the citizens of those countries who suddenly have, alternative processes that can help to clean house. But the last point I'll make here is that a lot of information is released in the process of a DPA. It's you know who took the bribe, you know the channels by which the bribe was given, you have usable evidence on the supply side. Why can't we leverage that and develop a set of incentives that will encourage cooperation on the side of the bribe taker? I have suggested, and there are already mechanisms of where properties are seized, funds are seized. We can use those same Magnitsky type orders and processes to create the incentive to cooperate. For example, you would very rarely have a straightforward transaction where I gave the bribe, someone else took the bribe, but you will have a chain of should we say, gatekeepers. All you need to do is to find the first name. This is just a suggestion, but I'm thinking about how do you create incentives. If you freeze the assets of that first name that came up, then there is suddenly an incentive to cooperate and say, I had nothing to do with it. All I did was to pass on this paper to B. And then, you can start creating a chain until you get to the final persons that you're looking for. Now, this is a very, very simplistic example, but the point I want to make here that even on the demand side, we have to look for ways to incentivize cooperation with the authorities. I really do think that this public-private cooperation mechanisms serve the fundamental purpose of bypassing compromised institutions and increasing risk and creating an environment where it makes sense to do the right thing. So it is that aspect. However it is done, it doesn't have to be a DPA, but that is the key. The structure is, if all the structure does is to encourage impunity, then clearly, we need to look for alternative structure.
This worked here in the UK. Section 7 is the stick. The DPA is the carrot. The DPA says, and it's in really simplistic terms, that the general trend of corporate criminal liability statutes is we make it much easier to prosecute a corporate and prove it because the burden of proof was too high in the past. And then we offer you leniency if you tell us about it first. And this is a U.S. judicial pragmatism at work. When DPAs were introduced in the U.S., and they had a long history, but when corporate DPAs came into pass, all that happened was one prosecutor, Joel Klein, who was working in this kind of dodgy outpost of the DOJ that was called the FCPA unit, which nobody had ever heard of and never prosecuted a case. All he did was put together the FCPA extraterritoriality with deferred prosecution agreements, which were traditionally used only to help teens not get convicted of crimes that were going to follow them through to adulthood. And he put these two pieces of law together with one other piece of law called the Federal Acquisition Regulations, which said that if you're under indictment for an economic crime offense of dishonesty, then the U.S. government will not transact with you. More importantly, the US government will not transact with anyone you transact with. So what Joel Klein's brilliant idea was, which has changed all of our, the course of all of our careers, is he said, so if I say, I suspect this company of FCPA breaches, and then I go to that company and I say, you need to sign this deferred prosecution agreement and pay me an immediate penalty. And if you don't, then the US government won't transact with you for the whole period that I'm investigating you. And God knows that'll take 10 years. So they won't transact with you, and they won't transact with anyone you transact with. So you just lost all your suppliers, all your customers, because the US government swings a very big stick. And it's only, and that arguably is enormous prosecutorial overreach, which should be prosecuted in its own right, but instead has become the example by which the rest of us are trying to govern our legal corporate criminal liability conduct. So, I guess we say from good comes some bad, or from bad comes some good, which in the US example, you can set alongside the prosecutors negotiating DPAs and insisting that one of the terms of those DPAs should be a donation to their alma mater, a charitable donation to their own law school, to the extent where you're negotiating a DPA to settle out another DPA that the prosecutor corruptly negotiated. There is no sphere in the world that is operating purely and beautifully. And if you want to understand how the other side is thinking, you kind of have to step into their shoes and walk a mile in them.
Well, can I jump in on this? Because there has been this discussion related to the Americanization of criminal justice in relation to corporate criminal liability. And I don't think many people would hold the US up as the best role model in this area. And interestingly, moving over to the UK approach with London buses, as you mentioned, you wait ages for one and then two come along together. What I find interesting is the time it has taken to develop this body of jurisprudence in the UK, because we are now at number 9, and it was expected there would be a lot more at this stage. So in a sense, it does seem that whether it's down to delays in the internal investigations or the discussions, negotiations between the company and the SFO, I don't know. So can I get your thoughts on that? Why is it taking so long for, and as I say, it could be a good thing, for only 9 to have been agreed so far? And can I bring in another question here about the nature of you see this probably in the Q&A, the nature of the agreement with the parent company, and what is the nature of that undertaking signed by the parent company, particularly in Serco and G4S?
So Natalie, the answer is yes. It is all contractual. It's just contractual. It's almost like a consent order. So it's contractual with the force of a judicial undertaking, or sorry, a judicial decision, a judicial finding. And if, excuse me, it has slightly more force than that, because of course, if any of the terms of the DPA are breached, then the penalty for breaching a DPA is that you get prosecuted. So it's like a contract with a bazooka. And it does make the undertakings have much greater force than if this was a pure extrajudicial contract, which hadn't actually had any court findings attached to it. Hopefully that answers the question. As to whether or not US jurisprudence is a model we should follow, I'm sure that we don't have time to go into that. Suffice to say, if you want to understand US jurisprudence, you have to understand pragmatism, because Americans think that you can solve everything with a shotgun. And that might be a metaphorical shotgun, like a deferred prosecution agreement sort of advocated and discussed by Joel Klein, where he just said, write me a check or I'll take away, like Standard Chartered, write me a check or I'll take away your New York banking license. You can't transact in dollars, I don't think you have a business anymore. So, enjoy your time in Purda. Or it might be a literal shotgun, as in the case of our current president. Anyway, so I don't want to distract myself there, but The problem that the rest of the world has, and I think that Abby has made a sort of cogent argument for the fact that these are issues that every jurisdiction has to grapple with. They're not unique to the UK, they're not unique to the US, and they just have slightly different flavors, whether you're coming from, like the way you expressed it, Abby, which is like, are you bribe side or take side? So there's distinctions there in terms of where your legal focus is going to be. But given that they're not unique, the question of whether or not we should follow the US example is simply a what do we have the stomach for? I think in the book, I tried to make a strong case, again, as an amateur academic, for the fact that US lawyers have a longer history of negotiated settlements. We plead everything. Like, my earliest memory is age 12, going to calendar court in Los Angeles with my auntie, who was a public defender, and sitting down over a pastrami sandwich with her and the prosecutor. Well, they carved a stack of cases this high. He'll plead to this, he'll plead to that. We'll take this. Yeah, I'll give him 5. He'll take 10. And that's just how US lawyers get through the enormous body of casework that they have, and arguably how we ended up with the prison population that we have. We don't have that example here in the UK. It took 5 long years to even get to Attorney General's guidance on whether or not you could have a plea agreement that still had to be certified by a judge. So I think whether or not you are going to get comfortable with a streamlined process to a negotiated outcome depends on whether you have a judicial history of being able to plead cases. How much are you ready to do outside of court? Abby said at the beginning, Judge Rakoff, who talked about window dressing, Judge Rakoff must have been an amateur interior designer, because the other thing he said was, when he finally had it up to here with DPAs, he said, what am I, a potted plant? He got furious under the HSBC DPA, because he said, if this misconduct is so sufficiently criminal that you want me to levy a fine of $2 billion, then it's criminal enough to prosecute. And I think the potted plant of Judge Rakoff kind of gives you an idea of how judges feel about this. They are the arbiter of penalty, not a negotiated outcome between a corporate that wants to see it done and dusted and a prosecutor who wants a quick and easy scalp.
Thanks, Polly. Can I have one follow-up point on this before I bring in Costantino and Abiola in relation to Tina's question in the Q&A? And Polly, it was mentioned in the discussion that we don't yet have cases where a company has breached a DPA or not even breached a DPA, but has agreed a DPA, and a couple of years later there is other conduct and they're looking to negotiate a DPA in that type of situation. And you mentioned HSBC, and HSBC is often held up as an example of negotiating DPAs in different jurisdictions for different conduct, and there has been criticism whether it is appropriate to offer a company more than one DPA because there's no clear effort at a change. Did you have any thoughts on that?
Yeah, I mean, looking for breach is tricky. I remember when I was preparing the book, I planned a whole chapter on breach. And then sadly, when I started doing the research, discovered there was only one example and it didn't even really qualify as a breach. There actually hasn't been a lot of breach cases, not least because DPAs are a great thing for corporates. They love them, not because the fines are less. They love them because it's on the balance sheet. It's predictable. There's no kind of endless outcome whereby you're sitting in the nervous courtroom waiting for a jury to come back and say, yes, we find that a 28 billion pound fine is going to be levied, and it's all been for nothing. So DPAs are enthusiastically endorsed by corporates once they get their heads around that they actually did something wrong. But when you look at the question of whether or not the victims can get any compensation, sorry, can I just say the one breach case is, and the reason it's an arguable breach case, is Standard Chartered. So Standard Chartered agreed its DPA, and they agreed as part of that a term which said that they would never resile from the points in the statement of facts. So everything that they accepted they had done, they would stand by that. Yes, we definitely did that. And then shortly thereafter, the chairman of Standard Chartered went on a press call with a number of investors and journalists and said, oh yeah, we didn't mean any of that. We only said that because we had to. It was just a quick and easy way to get it to go away. And Polly Greenberg, who was the Southern District District Attorney, turned up on his doorstep the next day. And she tells a wonderful story about that moment where she said, I'm not having that. We worked hard for this outcome. We're going to make sure it sticks. And so she threatened him with breach. And he then went back on a press call with the journalists and said, no, I'm sorry, we really did do it. And it really was quite naughty. So do the individuals get compensation? I was really interested in something that Abby said earlier when you were talking about Tanzania and the payments to Standard Bank. So £7 million went to Tanzania after the Standard Bank DPA. And that's good because the payment, the actual bribe, was $6 million. So that's a good outcome and good compensation. However, thinking back in time, when you look back at BAE, which was also a Tanzania case where Tanzania was a bribe was paid by BAE allegedly to buy an air traffic control system at a time where Tanzania did not actually have an airport. So there was clearly corruption in play there. Under that settlement, $28 million was paid back to Tanzania. And I was just kind of struck by that, like in the olden times where there was much more activist prosecutorial involvement and there wasn't a whole structure about how much got paid where and there weren't sentencing guidelines, it meant that prosecutors could actually pursue outcomes that felt right to them and that they could argue and justify and had sufficient evidence for. So where I think you're getting into stickier territory is where those victims are corporate. In other words, I pay a bribe in order to win a contract and somebody else doesn't get the contract because I've paid the bribe. My suggestion would be pursue that civilly because, of course, that is an unlawful means conspiracy. I would be happy to act for you. Here's my card.
Thanks, Polly. And Costantino, can I bring you in on this as well? So this issue of compensation, what are your views in relation to the role of compensation and whether victims should be compensated as part of a settlement? Or is there a risk that this could impact the negotiated facts of the case, or even whether a firm is inclined to self-report?
I think that is very important actually to offer compensation. And when I look at the first time to the English law that lists compensation in the potential terms of the agreement, but only as an illustrative list, my first reaction was this should be mandatory. So if you want to enter in a DPA, compensation should always be there, not subject to negotiation. But this is another point. So for the ICPC case, for example, that Polly mentioned, we calculated the compensation and it was a bit more than the bribe, Polly, just because we had to include interests. So we just included interest on this sum, but we gave exactly what the government didn't get. The real problem, Polly, was you were giving the money to the same government that was corrupt. But, you know, I don't want to open a Pandora box now about all this stuff because I told you, we can discuss for ages about these things. And I don't want to diminishing the importance of the Bribery Act and of the DPAs because, as you said, we changed something. It was totally a neglected black water. We were totally stuck in impunity. And this is true. So we are doing something now, but we have to go on, we have to correct the aim actually. We have to because we have to evolve. That's the point. So about the other problem that I think is more important is how you calculate the advantage, the profit that the corporation has got. You said if there is a damage for another company, for example, but also the company, when they have to give back what they got because of the bribe paid, it's not only, you know, the direct things that they get, but they are getting so many things. They can enter in a dominant position in the market. They can manipulate competition so that they have a competitor out of the game because of the bribe that has been paid. Has all this been calculated? No. So in an ordinary prosecution, it should have been calculated. In a DPA, not, because this is still part of the agreement. So you can negotiate to this. So that's the point. So I think that at least Abiola said something that I found very interesting, and this is true. If you think, for example, the issue of Tanzania, without this possibility, without the bribery act, without the DPA, nothing would happen in Tanzania. Now, actually, Abiola, they got some money there, but nobody was prosecuted. So at least we gave something to these people, and I totally agree with you, because they were the victims. And the idea that they have an alternative forum abroad is important. But then, if this is so important, we have to be more transparent. So the point is that we are speaking about human rights here. We are speaking about violation of important things. So if we are really going to the following the path that you said, we have to do it properly. So that's my point. I'm not diminishing the value that what we have done so far.
Abiola, can I give the last word to you? And I am conscious of time, and it shows how contentious and how fascinating this whole area of law is. And I'm sure we could stay here for another 2 hours having long debates, but conscious of time. So Abiola, can I give you the last word, picking up on either what Costantino has said there? And can I just ask, so one particular point you spoke about, the move from KYC to KYD, that is the way forward. Could you just say a brief bit about how we can improve the data that we can have access to, and how we can make better use of that?
Well, okay. Well, know your data. I threw it there because of the tsunami that we're all trying to figure out what to, how to deal with this, how to handle this. So I'd rather go to the topic of the victims, because I was rushing through my presentation. I actually had 2 slides on this, and I wanted to first of all commend the UK DPA Code of Practice, which has a similar provision to the Sapon-Do Code of equivalent of the Code of Practice, where express mention is made of victims, compensation for victims. I think as a concept, as a principle, it is good to get this into the narrative, because this is the shape of anti-bribery enforcement. We do not yet have, this is all has to be developed, but it's, I think the UK, the UK DPA regime and the Sapon-Do regime, by putting it there, it should be mandatory, I quite agree, but at least articulating this as a part of the settlements process is progress. I think it's also important to the point very quickly of who is the victim. And I think here we have to be very creative. And if we look at the different initiatives, we see that there's a spectrum of how this can be dealt with. Abigail Bellows with the Crook Act in the States is talking about an anti-corruption fund, which is similar to the line item. Once you have a settlement, you have a line item, and a certain amount is included in the settlement. If you cannot identify a particular victim, it goes into a fund. The Siemens World Bank Integrity Initiative of $100 million was, after all, an outcome that led to a lot of anti-corruption initiatives for a huge amount of people, where damage was dispersed. They couldn't find a particular victim, but there was compensation. So how we define compensation is going to have to be a lot broader than that one individual here or there. Damage is dispersed, but it doesn't mean we cannot go and develop and use these provisions that speak about compensation. I have in the past written about using third-party beneficiary clauses to identify ultimate beneficiaries of public contracts who will now have the locus standi to be able to benefit from Section 7.2 of the UK DPA and such type of rules. But the last point I will say here is I remember when Abacha was a former head of state in Nigeria, who had, hemorrhaged millions and millions of the funds of poor citizens into Swiss bank accounts. And at that time, when there was the decision made that Abacha's, this is how it came across in the public media, Abacha's millions were going to be returned to Nigeria. We had no illusions about the fact that it was coming into a clean country. It was going to end up in the same corrupt pool. But that wasn't the point. We were shocked that it was happening at all. So it piercing the veneer of impunity in itself by making certain things possible is the beginning of the journey to, transparency and all the other things. We shouldn't underestimate how that action then gave hope to hundreds of citizens who now suddenly saw, hundreds of thousands or millions of citizens who suddenly saw new possibilities where none existed before. The architecture is very young. And I think looking forward over the next decade, so maybe Colin will organize another webinar in 10 years' time. I don't know where we'll all be. It will be very interesting to see how these emerging issues, which are being identified, some of them have been identified tonight, have been tackled, and what kind of policies, strategies, mechanisms have developed out of these, should we say, very tender shoots that are springing up. So I think I'll leave it there and just say, civil society has a role to play, and I think the role has to be as much forward-looking as it is, comparing this to what we had in the past. So that's what I would say about that. Thank you.
Thanks, Abiola, and thanks to all of our three speakers for a fascinating discussion. I really enjoyed it, and it certainly does give a lot of food for thought going forward. We do have one final webinar remaining in this series on the Bribery Act. So next week we look at international and comparative perspectives on anti-bribery. So we hope that you'll be able to join us for that webinar next week. Thanks again for everything, and good night to all.